Hi, my name is Elias Ruiz, and this is my final project for education law. I chose to focus on non-renewal for public employees, and I'm going to sprinkle in some information too about retaliation and equal protection rights for those employees. As you can see on this slide, the assignment was to find a topic in this textbook and to expand on that topic, so that's exactly what I plan to do. As you can see, non-renewal was brought up on page 130, and as you can see in bullet point 2 that non-renewal is distinguished from other forms of dismissal or termination, including even mid-year dismissals as far as public employees go. You can be terminated mid-year for different reasons. You can also have what's called a contract non-renewal, which I'll define on the next slide. So what is non-renewal? Non-renewal generally means you have a contract with the school district until the last day in June or somewhere around that time. Now, the school can do two things. They can notify you that they plan on hiring you for the next year, or actually, they just don't have to give you notice, and that means they're going to hire you for the next year. Or they have to give you some type of notice that says you're not being reelected for the next school year. In that case, the contract terminates in June, and you're basically not invited back for the next school year. Okay, now that we have that basis covered, I want to just kind of outline my presentation here. I'm going to have an introduction. I'm going to give some legal framework. And again, like I said, I'm going to sprinkle in some equal protection information and retaliation and end off with a conclusion. The reason I chose to expand on non-renewal is because, first of all, I'm a public school teacher, and I've seen a few things in my years where I don't think it's quite fair for probationary teachers who are being non-reelected and they don't really have many rights as far as property rights in their job, and they can be let go. Now, the reason I find that to be a little troubling is no cause generally has to be given, and there's no procedural safeguards as far as requesting a hearing. You can respond, you have about 10 days to respond to your notice of non-renewal. However, you're not guaranteed a hearing, and there doesn't even have to be any reason why they're letting you go. Now, again, the reason I'm saying this is unequal is because there are certain probationary teachers in California that do have the right to notice and a hearing if they get non-reelected. But I'll go into the specifics as we get through this presentation. So what I plan on starting off with is the statutes in California. There's a California Education Code 44929.21, which states that at school districts with 250 or more students in average daily attendance, those employees that are certificated employees, they can be non-renewed at any time, again terminating at the end of the school year, so long as they're given notice prior to March 15th of their second year. And again, that in the statute it says that they have no right to, actually the statute doesn't say that. I'm going to get to a court case later on that talks about what that actually means. The statute that I just referenced, which is 44929.21 of the California Education Code. Now, there's another code that I like to bring up at this time too. That code is 44948.5, again, California Education Code. And that is another section of the code that states that probationary employees at school districts with less than 250 students in average daily attendance, they actually have the right to, when they are notified that they're not being reelected, the governing board has to give them a reason why they're not being reelected. And then that probationary teacher has the ability to demand a hearing to make sure that they have appropriate cause for being dismissed or non-renewed, I should say. On that last slide, I started to jump ahead of myself a little bit. But this statute here, I'm sorry, not statute, this case law was interpreting a statute that I was talking about earlier, which was the 44929.21 section of the California Education Code. When a couple teachers got non-reelected in 1983. Oh, I take that back. I'm looking at the date here now. Anyway, the laws changed in California in 1983, and what that did is it when this case started, there was kind of a dispute about what does non-renewal mean compared to another statute, which here you can see is 44948.3. And in that case, Grimsley versus Board of Trustees, it was basically argued that, well, look, the legislature didn't mean for probationary employees to have a cause given, because if they wanted that to mean that, then it would have been like this other code, which is 44948.3 and 44948.3 states that there has to be cause given for mid-year dismissals. So what happened is they basically distinguished whether you need cause given or not for renewals, because in that statute that I gave you earlier, the 1.21, doesn't have anything about um, giving cause. So this statute does, though. If you get rid of a teacher mid-year, that means effective mid-year, not effective at the end of the year, not getting notice in the middle of the year and having to be effectuated at the end of the year. But if you get terminated in the middle of the school year, then there has to be a cause, and then you have some rights, and those are still not equal either. But I'm not going to go into that because it's a little too deep in the rabbit hole for my purposes. So this case again distinguished what rights probationary teachers have, at least in districts with 250 or more students in average daily attendance. Well, let's keep going. So, due to that last case, the Grimsley case, there were a couple other cases that followed that also clarified the case law on that statute. Again, that statute is 44929.21 of the California Education Code. And one of those other cases is the one in this first bullet point, which is Board of Education versus the Brown Valleys Teacher Association. And what they solidified here is that probationary teachers can be, at least at school districts with more than 250 students in average daily attendance, they can be non-renewed with zero cause and no right to appeal. Again, but there is a section of the statute that does, at least the one I had just mentioned a second ago on the last slide, where you do have the right to respond within 10 days of being notified. Again, it's not a hearing. It's not in front of there is no hearing. You just get to basically say your last word, and it becomes part of the record. I don't know really how much that will do for somebody who's been non-reelected. Probably not much, but you do get to at least have the final word. Okay, so the next case here is Cousins versus Weaverville Elementary School. And what this is not 100% relevant here, but it basically says if there's a statute or two statutes, right, and one of them is more specific for a specific scenario, it trumps the broader statute, which is more general. So it wasn't particularly the statutes that I'm referencing. I mean they are close. It is comparing 44955 to 44929.21, but the reason I bring it up is 44948.5 is a more specific statute, and it would apply to probationary teachers in school districts that have less than 250 students. So it basically trumps or preempts this other statute that I'm kind of concerned about, which is the Ed Code 44929.21. And we'll talk about that statute here in just a second. I might have mentioned it earlier. If I get to the next slide and find out I didn't, I'll definitely tell you what that statute includes. Well, I must have already covered that statute, but let me just, for review purposes, bring it up here again. So um, I believe it's 44948.5 California Education Code. Basically what that is, again, is it gives probationary employees at school districts with less than 250 students in average daily attendance, it gives them the right to have cause for non-renewal, and it gives them the right to a hearing. So again, later on I will be bringing up equal protection clause issues and why I think that it's unfair and there should be more due process for teachers at school districts with over 250 students in their district. Okay, but let me get on to PERB here. So one of the last cases I gave you, especially the Round Valley versus the Board of Education, what happened in that case again is it stated that there's no cause that has to be given, and there's no appeal to that decision, and somebody can be non-reelected with basically they can't really do anything about it. It just gives the school districts a lot of power to determine who finally makes it to that permanent status, where then a lot more due process is afforded to those employees. It gives schools discretion to weed out candidates that they don't really feel can do the demands or the essential functions of the job. However, there are some issues, or there's some instances where employees still have protections that's not really outright stated in Ed Code, but it is out there. So for example, there's a government code called the Educational Employment Relation Act that states that employees cannot be retaliated against basically for conducting and protected activities. And this is why I bring up PERB on this slide, because it talks about the Public Employment Relations Board, and really that's what its job is to do, is to enforce that government code. Let me see here, I'm looking at the second one. Yeah, so there it is. It's already written right there. I was just going to say it. Probably shouldn't have even paused to read it. But basically, PERB has the right to, when a non, let's see, let's say non-renewed, but when a probationary teacher is non-renewed, PERB has said that those people cannot be non-renewed for unlawful purposes, basically. So for retaliation. So even though 9929.21 and its case law state that no cause has to be given and there's no right to a hearing, it has been even further distinguished to state that no cause, so basically somebody can be non-renewed for no cause or a lawful cause, but not for an unlawful cause. So let's dive into that a little bit. So as I said earlier, PERB has carved out some protections for probationary teachers in two PERB decisions here. Well, actually, this is one PERB decision. That decision was Decision 786, and the E stands for EERA, or the Educational Employment Relations Act. And then there was a case that affirmed PERB's decision, and again, that basically states that probationary students cannot be let go for unlawful purposes, and one of those unlawful purposes is violations of the employment, or the EERA, Educational Employment Relations Act violations. So if somebody's conducted in protected activity under EERA, then PERB, the quasi-judicial I guess you could say, administrative branch of California that looks out for public employees' rights has the first swing at, I guess you could say. They have jurisdiction over whether somebody is being discriminated against or retaliated against for unlawful purposes, and they have the power to reinstate um, probationary teachers who've been non-renewed, even though, again, the statute says there's no hearing, there's no cause has to be given. Well, there are some, fortunately, there are some protections that do exist, and that's what I'm going through now, a list of some of those protections. So, although these two decisions didn't turn out great for the plaintiff because they didn't win, they did help refine the law in this area. So in this first case, Walnut Valley Unified School District, and the second one, Eugene Smith versus Antelope Valley Unified School District, they added a little bit of detail to what counts as protected activity. So in this first one, protected activity is basically any time you're conducting in union type activities, either advocating for the group or yourself. And there's many more provisions that get into even more fine-grained activity that counts as protected activity. But again, I just wanted to focus on a couple statutes, and this is one of them where the scope of ERA's protections is defined a little bit more fine-grained. And then in the second one, again, this didn't work out for the plaintiff in this case, or the complainant, but it does help refine the statute here that this person in this case was retaliated against. Here's one thing I don't really like about Prob either. They have a little bit of a higher standard. So even if you were retaliated against for ERA protected activities, it has to be like the motivating factor, like mostly for that reason. So even if they have a legitimate reason to non-reelect somebody, and it's a mixed motive basically, if they had a legitimate reason, even though there's some retaliation or discrimination, then Prob will let that non-renewal go. That's different in civil court, which I'll talk about here later on. But again, these are some of the decisions that helped refine how these situations work their way through either administrative processes or civil processes. So in this decision, this one is just kind of showing that like school districts are trying to push back on Prob that hey, we don't have to give any cause, or when we do have to give a cause, we have so much latitude in these areas. And in this decision, basically Prob is stating that okay, so there's some education codes that you're trying to use in your defense, and under these governmental codes for ERA, they're basically stating that they don't conflict. Basically, it says that Prob has the authority to review those non-renewals to make sure that there is no unlawful activity, regardless of what the statutes say, the Ed Code statutes, where it says no cause has to be given, or certain types of causes have to be given, or certain procedures have to be taken in those hearings. Again, Prob here in this decision is stating, look, there's no conflict. You have your Ed Code statutes that you have to follow them, but we are still allowed to review what you've been doing under Ed Code to make sure that there's no underlying unlawful reasons why you're letting these I keep wanting to say non-renewed, but probationary employees, why they're being non-renewed. So as I've been hinting since the beginning of this presentation, I do think that there's an angle that probationary teachers could use to leverage, at least, to try and keep their jobs, and that angle is equal protection. So under the U.S. Constitution and California Constitution, they both basically state that anyone who's similarly situated should be treated similarly. Now, that's more so protected there's more protection. There's layers of protection here. So some unequal protection cases have to deal with strict scrutiny, some are intermediate scrutiny, and in this case, it's what we call rational basis review. So the case that I have here on the screen is talking about how public employees basically fall under rational basis review, which is not great for public employees because it gives the government the upper hand. Really, all the government needs to do in that case is show some rational reason why the statutes are unequal or why there's unequal treatment. And as long as there's a legitimate reason, then the courts will allow that discrimination or unequal treatment to persist. It would be considered constitutional. So, anyhow, there's equal protection does apply, but again, the protection is weak, but it's still there, and I'll talk a little bit more about that later on in a different slide. Just to refresh your memories again, if you forgot, here's why I'm bringing up the equal protection um, angle, at least that non-renewed probationary teachers could try to argue. It's these two statutes that I'm looking at in front of me. So it's 44948.5 and 44929.21. And again, the .21 statute is saying that anytime a school district has 250 or more students, then for some reason those certificated employees that work there can be non-renewed with no cause and no right to a hearing. Now, if it's a smaller district under 44948.5, that means less than 250 students, those teachers, still certificated through the state, same certification process, those teachers have to be given a reason why they're being non-renewed, and if they demand a hearing, they have the right to a hearing, and it's it gives them more process, or at least procedures or due process, and it gives them some more job security because they have a way to kind of like peek under the hood and find out what's going on, why they're not being renewed, and is it for legitimate purposes. Again, if you work at a larger district though, none of those protections exist for you. So again, those are not equal. Now here's what I think is a current, it's not super strong, but it's more of a current issue with these statutes because the legislature out here in California, or at least a couple legislators, in 2022 tried to pass, or they brought a bill up that got, it got pretty high up in there, but it got to appropriations and died in appropriations. And what they tried to do is amend these statutes to make it more equal and get rid of that disparity between the, again, similarly situated people, but they have these different outcomes because there's not equal protections for those same class of people. The only difference here is not between the certifications, not between the job duties. The only difference is the number of students that go to that school district. So they tried to equal that out, but it died in appropriations, wasn't funded basically. And to me though, that hints that maybe there's not a rational basis why these two statutes are different, and this is maybe why the legislators tried to fix it back in 2022. Well, I just noticed I kind of already gave the rundown of this assembly bill, but here it is again. It was brought up in February 18th of 2022, and it was last amended in June 13th, 2022, and it went to appropriations where again it died. But as you can see up here in the details, they were basically trying to amend and repeal certain sections of the statutes that I was talking about, and you can see in these parentheses that the two statutes that I'm concerned about here are included. And again, the goal here was to standardize the the process for becoming permanent employee and to standardize a way to non-renew these probationary employees so that there's not that unequal treatment. So again, I include a slide to just emphasize again that point that if the legislators believe that there's inequalities in the laws and they try to change those laws, it just hints again at the fact that there may be some arbitrary state action when it comes to probationary employees here in California that are trying to work at school districts and have some kind of property interest in their jobs, but are being treated unequally just because the number of students that are in that district. Really doesn't sound fair to me. But again, this would have to go to court. Someone would have to have standing and challenge this, or we'd have to get something passed in the legislature to get these things changed. So I brought up this statute earlier in my presentation, but I'm coming back to it again. Grimsley versus Board of Trustees back in 1987, about 4 years after the statute was in place for the new way to make probationary employees permanent, at least at school districts with more than 250 students. Now, that statute again doesn't really say that employees don't get any rights as far as cause doesn't have to, there's no cause that has to be stated, and it also doesn't say that they don't have any um, right to a hearing. It also doesn't say that they do. So this case kind of solidified that point, because what they did again in this case is compared to another statute that says, hey, for mid-year um, dismissals, then those employees do have the right to cause and a hearing. But it doesn't say it over here in point 21. So again, that's how it got eliminated, was this case, and that's, I believe, why there might be some disparity. The legislature didn't include it, but the case law, determined that, hey, those safeguards don't exist. So it was basically from the bench that this circumstance arose. On this slide, I'm just listing a couple more cases. It looks like I forgot one of my links here too. I put these links for myself, especially, so a lot of this research I like to go back and look at, and I like to link to these cases in Westlaw so I can go ahead and look at them. A lot of times too, I like to listen to these cases from beginning to end, so it's just the easy way to access them. But anyway, the Long Beach City Employees Association versus City of Long Beach case, I did reference that one earlier. Again, all of these cases are basically pointing to the fact that public employees do have the right to not be treated arbitrarily. So at least rational basis review, again, is there for those employees. I know it's not strong, but these cases do solidify that point, that an argument can be brought from that perspective. Not easy to win, but again, I still believe that the assembly bill that the legislators brought up recently adds a little heft to that argument. Alright, time to expand on the retaliation protections that do exist for public employees. This first case was also in our book. This is the Pickering versus Board of Education case, basically stating that public employees, they don't lose their First Amendment rights at the school gate, or whatever, however they stated that exactly. I don't remember the exact quote. But, public employees can bring up matters of public concern, especially as private citizens, about, things that are going on in that school. They're better suited than other people to know what's going on in those public schools. So if they bring up something that's a matter of public concern as a private citizen, then they have First Amendment protections, and they get to say stuff like whistleblowers, right? They can say something to some governmental agency to rat out something that's going on bad at that school and be protected under the First Amendment. And again, that was a Pickering versus Board of Education that gives them some free speech protections, in at least from being non-reelected for retaliatory purposes. Here I have a list of some more cases dealing with the First Amendment speech retaliation balancing test. In this case, I've ended this list with a case here in the Ninth Circuit, which covers California, and it includes public employees, in this case a police officer. And basically what this case did is it made it a very fact-specific test to see if what that employee is saying is an official duty of that employee, or whether it can fall under protected speech because it's being stated outside of those job duties. So the courts really need to look to see the circumstances that are involved around what was said, who it was said to. Does it include um, matters of public concern? Is it in the scope of those job duties or not? And if it's not, then it's protected speech. And if there's any adverse actions taken against that employee in that case, then that's basically retaliation and illegal. So, what constitutes whistleblowing, and does it apply to public school teachers? Well, fortunately, there are technically two statutes here in California that do cover public school teachers, and that's Labor Code Section 1102.5, which was amended, I believe, in 2014 to explicitly include um, public employees or governmental employees who report, you know, improper governmental activities, basically. And the reason the legislature went back in 2014 and amended this section is because there was a case in 2012 where a public employee was arguing for some cause, or I can't remember exactly what it was, but what happened is that court case ended with this odd um, ruling, which was that labor codes do not apply in California to public employees unless those labor codes specifically state that they apply to public employees. So that basically wiped all of the labor codes off the slate as applying to public employees unless those statutes specifically said they do apply to public employees. And there's only a couple, three or four, that were still on the books at that point for public employees. Now, again, the legislature went back and amended this statute to include public employees. As you can see at the bottom of the list, too, there was even a more specific statute that was enacted. I believe this one was in 2018, and it was enacted for specifically for school employees. And it even actually covers other people. So if you look at the statute, if you look at the first section, I believe, or the second section here, 44111 defines school employees, and it also defines people as well. So even if you're not a school employee and you're bringing up stuff about a school, this could also protect you. These are nice too because they include punitive damages and fines for those people that retaliate against those employees. Now this middle one, it sounds good, and I just wanted to bring this one up because it does cover. It's called the California Whistleblower Protection Act, and again, it does cover the reporting of improper governmental activities, but it says state employees. And the reason I bring up the statute is I know we talked about state employees here in this course, and how basically teachers are not state employees, but I wish I had it in front of me and I don't have it right now, but there's a way to construe that a public school employee is an employee of the state. It's a bit of a stretch, so I didn't really include it in here. And this again doesn't really apply to teachers, but I believe there's a way to construe that does cover teachers. But it's kind of a moot point because again, the labor code at the top and the labor code at the bottom, or the education code here at the bottom, basically give those teachers those whistleblower protections, and that middle point is not really necessary. I brought it up because in the past, because again these are relatively new statutes, 2014, 2018, this government code might have covered teachers if you could argue it a certain way, but again I just bring it up because it was somewhat relevant. All right, let's get on to the next one. In earlier slides, I raised the issue of some of these statutes and Prob, and again, here's just some case law that goes with that. some of those protections against retaliation. So one of those is the whistleblower statutes of the ones specifically designed for public employees, Section 44110 to Section 44114. And there's a court case called Connor versus Placer Unified School District, which in that case, it specifically states that um, probationary teachers, specifically, again, probationary teachers are considered protected under this statute. So the way that it defines employees in that statute, this court case, although it doesn't say it in the statute itself, this court case says probationary teachers are employees and covered under this statute. So that's a super important case. And then there's a couple other ones here that deal with ERA. Remember, ERA is a government code out here in California. And in that government code, it specifically states, too, that you cannot be retaliated against for conducting in any protected activities under ERA, again, which is the Educational Employment Relations Act, and that is to basically that statute is basically there to protect employees that conduct a protected activity. And again, there's a long list of protected activities, but some of those include like union activities, standing up for contractual rights and work conditions, and there's a long list of those things. But if whatever that employee is bringing up, if it's a protected concern under the ERA statutes here in California, then PERB can again look under the hood and find out if the employer is doing anything unlawful to try and get rid of that employee. Let me see, am I missing anything on this slide? No, there it is again. It says right there, the statute prohibits public school employees from retaliating against employees for engaging in protected activities under ERA. So there's a bunch of decisions in PERB that do talk about the specific protections that employees have. I'm not going to go into all of that here, but if again, someone's retaliated against for conducting a protected activity, PERB can take a look at it and make sure that it's not for retaliatory or discriminatory purposes, even though some of the education code statutes don't give those employees those rights. So here we are at the conclusion. In these next two slides, I just want to kind of recap what's been said from the beginning. Again, this whole presentation is about the non-renewal of basically probationary employees out here in California. What's interesting again in California is the laws are not equal regarding probationary employees because there's really two laws on the books. One deals with schools that have over 250 employees. I'm sorry, not employees, students in average daily attendance. So if you're at a larger school district and you're probationary, you have less rights. They do not have to give you cause, and you are not entitled to a hearing. You can give a written response to the notice of non-renewal, but that's really not anything powerful other than letting you kind of vent before they cut off your contract at the end of the school year, or not cut it off, but not renew it for the next school year. Again, there is also a statute in the books under Education Code that allows probationary employees at school districts less than 250 students the ability to not only receive a reason why they're being non-reelected, it also gives them the right to a hearing to really dig in and find out if what they're stating, at least the governing board of the school district, what they're stating is not arbitrary and is founded in some kind of facts. So again, there's just on the face, there's some inequalities there. Okay, so how come again the statute under 44929.21 got to be that way? Well, there was that court case with the Grimsley versus Board of Trustees that distinguished that particular law from another law in the books and said, well, if the legislature wanted them to have hearings and a cause, then they would have said that. And again, that's a different statute. That's 449948.3, which is not on this slide. But again, that kind of basically, if there was any hope for probationary employees under that statute based on older statutes, that was removed at that point in that case. So, and then again, that was re-emphasized in the Board of Education for the Round Valley case, Board of Education versus Round Valley, that yeah, probationary teachers at school districts with more than 250 students, they have, the board doesn't have to give any reason and doesn't have to give them any chance of appeal, hearing, nothing. Bye, basically. Um, let's see here. Make sure I got everything covered on this case. Okay, so I'm looking at some of these cases, and basically some of these cases are talking again. What I brought up earlier is that equal protection point of view, that because these statutes are not really equal. I mean, if you think about it, both probationary teachers at larger school districts and smaller school districts, they have to get credentialed. It's a statewide credentialing system. They're basically doing the same job as someone else at a larger or smaller district. They have the same state standards. They have the same state testing. They have the same, very similar hours. So they're very similarly situated. But again, when it comes to that property right, or at least due process in that case, it's really different when it comes to non-renewal. All right, let me get to the next part of my conclusion so you can see that while I'm talking about it. So again, as I was talking about on that last slide, I do believe that there's a little bit of equal protection. Again, an angle about equal protection that these non-renewed probationary employees can bring up. And I saw it on the last slide and I didn't say it there, but I'll say it here. There was that assembly bill that tried to equalize those statutes back in 2022, but it died in appropriations. So I'm thinking, anyone who's non-reelected after 2022 can at least bring that up, stating that, look, the legislators even thought that the statutes are not equal. They tried to equalize them, so maybe there is no rational basis for the way the statutes are. And again, the reason the statutes are kind of like that too is because of a case law, not really the legislature, you can argue, because I know the legislature back in the 80s, 1983, didn't state that they were supposed to be given cause or any hearing. It also didn't say that they couldn't, but that one case, again, that Grimsley case, really ripped that out, and then the Round Valley case said, yep, they don't get anything. So really the only fallback I see for those employees, again, is two things. Like I've already said, the equal protection argument, and the other is just retaliation. So the courts have ruled, again, that even though under the California Education Code they're not allowed, or school districts don't have to give them a cause, don't have to give them a hearing, no appeal, nothing, they can't use that as a guise to get rid of people for retaliatory and discriminatory purposes. So some of the cases I cited there were like the Pickering versus Board of Education, which allows you to have free speech. I also quoted some statutes from California, like the California Whistleblower Protection Act and the California Employee Whistleblower Protection Act. I'm just summarizing here, so I'm not 100% sure if those are accurate titles, but the statutes are here on the slide if you want to take a look at those. And again, those do protect teachers from retaliatory non-renewal. So again, even though it doesn't say in the Ed Code, there are some protections there, including, I forgot to mention this one again in my recap, in Prob. Prob will also protect those non-renewed probationary employees if they see any violations of ERA. So basically, again, if they've been non-renewed for any unlawful purpose, whistleblowing, First Amendment, ERA protected activities, then they do have a possible way to finally get some remedy, and which that's where it leads me to this very last statute, which I haven't even brought up until now. Is I love this statute because it says this: for every wrong there's a remedy. And again, that's California Civil Code section 3523. And that wraps up my conclusion, or my presentation. I'm concluding my presentation on non-renewal of probationary employees, or at least school workers out here in California. And that's my deep dive into some of the statutes that have shaped this area of law and my take on it, where I still think there's room for improvement for those non-renewed probationary employees, especially at school districts with less than 250 students. If you have any questions, please let me know. If you've seen anything wrong in this presentation, I'd love to hear it. I don't want to go around thinking I know the law in this area when I don't. So again, if you have any questions, or if you'd like to add any facts to this, please contact me and let me know. Thank you.